Well, welcome everybody, and welcome to another episode of Shorr Solutions, the webinar in conjunction with Shorr Solutions, the podcast. And I'm your host, Jay Shorr. I'm a practice management consultant specializing in the operational, administrative, financial health and guidance of your aesthetic, cosmetic, and surgical practice. And today I have the pleasure of welcoming a colleague of mine, Michael Wild, who is the managing partner of WFP Law Firm and specializing in wills, trusts, and estates. So Jay, why did you ask Michael to be your guest today? Quite simple. Michael and his firm are my personal attorneys. And there are attorneys for our wills, trust, and estate planning. And I felt, who better than to ask from somebody who I trust that handles all of my financial portions of my life in my wills, trust, and estate. So Michael, welcome aboard.
Great to be here. Thanks for having me.
All right. So what we're going to talk about today are key elements for estate planning in your aesthetic medical practice. And, you know, I want to share something as we get started and why this particular process is very, very important to me. For those of you who know me, no explanation is necessary. For those of you who don't, please allow me to share that I was a partner in a very, very large medical practice early in the 2000s. I came in the 2000s, and I want to make a disclaimer, I am not a physician. In the state of Florida, you can be a partner or an associate in a medical practice with the corporate practice of medicine. And we had several different offices. And in late 2011, actually November of 2011, the medical director was diagnosed with stage 4 cancer. And in June of 2012, the medical director passed away and from stage 4 cancer. And the reason that this is so near and dear and important to me is a medical director was my late wife. And I was ill prepared to face what I was about to face. Why? Quite frankly, I didn't know what I didn't know. And for those of you who know me, know what I was about to face because I've shared it many, many times. And directly after that, I went through a lot of stages of shock and anger and denial because a loved one who was my business partner or anything like that was going through a catastrophic event. I did everything I could to try to save her life, all to no avail, other than maybe sustain it a little bit longer, but the inevitable was inevitable. Shortly thereafter, I came upon a patient who happened to have been a patient in the practice because I had a locum tenens in there handling things till we were able to shut it down, eventually sell it. And he knew the story and he said, you know, I think you should talk to a friend of mine. And I said, who is that? And he mentioned Michael Wild. And I had known, actually, very interesting, I had known Michael's family for many years before, but I'd only come across Michael once or twice, never professionally, only on a personal level. And at which point I said, let me make a consult. And I scheduled a consult because I needed to know, what do I do from here? What has happened has already happened, but now how do I prevent another unearthing situation from happening to me? And that's exactly what I did. So I called Michael, set up the consult, and we talked about estate planning and asset protection. 4 words. Estate planning and asset protection. You've heard it, but do you really know what it is? So Michael, let's talk. What's the difference between estate planning and asset protection?
Well, estate planning is what happens to your stuff when you die. And asset protection is what happens to your stuff while you're alive. And in both situations, there's other entities that want to take your stuff from you or your beneficiaries.
I love that word, stuff. Stuff. We all have stuff.
It's a legal term. So what I always like to tell my clients, the death rate in Florida is 100%. So everyone's going to eventually die, and that's the death rate for anywhere you're watching this at home from whatever state or country you're in right now. But the other part is, if you're lucky enough to accumulate assets and live long enough, you're also probably going to get sued at some point. There's probably going to be someone coming after your stuff. And so what we talk about with all of our clients is those threats that occur during life and those threats that occur at death. And there's different levels of each, obviously. People that while they're alive that own their own businesses like I do and like you do, people that, especially in the medical profession, it's a highly litigious profession, people that own real estate or people that are I have a lot of clients that deal with electrical engineering or generators, high litigious businesses. Those need to worry about what's going to happen to their assets now, making sure that they separate assets from liabilities. But then everyone, no matter what they do for a living, no matter what assets they've accumulated, needs to worry about, well, what's going to happen to my family after something happens to me?
All right. So asset protection. Everybody that's participating and that will eventually listen to this webinar or podcast, whether it's live or recorded, are in the medical profession, all right, whether they're a doctor or not. And let's talk about asset protection before we speak about anything else, because what's very important in the medicine end, we're always afraid of being sued for, we have professional liability insurance for that ugly word called malpractice. Now, malpractice is in your business, errors and omissions in the law. Malpractice is in building and construction. It's in medicine. So what is asset protection? What does it really mean?
So there are different threats that can come at you from different angles. That litigation is the one that's most prevalent, the thing we focus most on, but it can be anything. It could be creditors, it can be bankruptcy, it could be divorce. Any number of things can happen to us during our lifetimes. Now, when we're talking about protecting the business, especially a medical practice, there are unique hurdles. Especially here in the state of Florida, a few years ago, they passed a law that said it's like 3 strikes and you're outlaw. If you get sued for malpractice 3 times, even if you found not guilty on all 3 times, still you could lose your medical license. And what we ended up having is a bunch of doctors who wouldn't carry medical malpractice insurance, rightfully so, because pragmatically, the more insurance you have, the more chance there is you're going to get sued, because some attorney says, okay, I'll make a phone call. I'll get a payout from the insurance company. I'll keep 1/3 of it for myself for making that phone call. And then that's the end of it. Well, that became a problem. So now we have a bunch of doctors that are not covered because they're not working for big hospitals where they have deep pockets. They have their own practices. A lot of my clients in this industry handle things like cosmetic surgery where they have their own practices, varicose veins, Botox, things like that, where you're touching people, or you have employees that are touching people, which is even more dangerous, and they're not carrying malpractice insurance. So they come to me and they say, well, how do we protect ourselves? We don't have the insurance. And the way you do that is by setting up what I call a series LLC, which has a parent company and then subsidiary companies, and each of the subsidiary companies holds a different liability. So we have staffing in one, we have vehicles in one, we have equipment in one, we have services in one, whatever it might be. And we address it in a way where if something does happen, it is contained in that one subsidiary entity and it doesn't spread or infect the rest of the assets. We want to make sure the assets are shielded from the liability. Now, some things are assets and liabilities, like, for instance, a building. If you own the building that your practice is in, it's very important to segregate the building from the practice. You don't want it under the same entity. You want a lease agreement between the two. I have actually one client, he owns a medical practice in Dallas. It's very high, not high profile, but it's very dangerous, really, as far as litigation goes, because all of his clients are children with diseases or ailments that require 24-hour attention. And these children are transported back and forth from the facilities that he owns throughout Texas to their homes. And they have buses that go and do this. And when I first was doing his protection plan, he had the buses owned by the same company that was actually serving the children. And it was all owned by one entity. And I asked him to separate that. It was actually costly for him because he did have to transfer the buses, had to change the insurance, had to now have the drivers change their employment to be through the bus company instead of through his company, and had to create lease agreements between. But then what happened a couple of years later is one of those buses hit a driver that was in front of them. And that driver was a pregnant woman who was sent into labor, early labor, with 2 premature twins. And luckily, those twins were born with no ailments and they're healthy and they're fine, but it could have been bad. Now, because he had changed everything, when he called me up frantically, I said to him, did you do what I asked you to do in moving those buses? He said, yes, they're not owned by my company anymore. I said, then you're fine. Then you're fine. In the worst case scenario, if they go beyond the insurance, they can take the bus. Who cares? But they're not going after the business. And having that kind of preparation is so important when you have a business that is in that highly litigious area.
Yeah, it's very important to note that what Michael is speaking about with not carrying professional liability in the state of Florida, there are 3 options in the state of Florida. You do not have to carry professional liability in the state of Florida. There are limits of 100, 300, and 250, 750. But the 3 options in the state of Florida, which have to be submitted to the Board of Medicine on record, are you can go bare, it's what we call bare, and you don't have to have professional liability, but you have to be personally responsible if a judgment is awarded against you, and if you can't pay it, you will lose your license. The other option is posting an irrevocable letter of credit through a financial institution. And the other is having professional liability in those limits of 100, 300, or 250, 750. Many states do not have that option of going bare. So when Michael talked about not having professional liability insurance, he really was mentioning to those states similar to that of Florida that have that type of a standard. So what amount of money do you have to have in an estate?
Well, a lot of people make the idea or have the idea that having an estate means you're rich, because the idea of having an estate, you think of like a real estate, like a mansion. But in reality, an estate starts, depending what state you're in, at whatever that level that probate kicks in. In Florida, that level is $75,000. So if you have more than $75,000, you have a probatable estate. Now, everyone has an estate, even if you have $0 technically, but when do you need estate planning? It really kicks in at $75,000. I do not have any clients that have a net worth of less than $75,000. Right. Not that I'm not happy to help everybody. It's just that it probably isn't economically in their best interest to hire an attorney to protect an estate of less than $75,000. But I do have clients that don't have to be, estate taxable to be estate probatable, which means that a lot of times people think, well, the estate tax exemption is so high right now. The estate tax, like this year, it's $13 million, almost $13 million per spouse. That changes year to year. It's been as low as $400,000 per spouse. But people think, well, I'm not going to have to pay estate tax. Why do I need a trust? Why do I don't have an estate. But in reality, having that trust in place is much more important than just the estate tax, because probate is the main threat that we want to avoid. Probate is when all the assets in your name go through the court system at the time of your death, and they have to be cleaned. And they're cleaned by the court by making sure that the state gets paid, the court gets paid, the taxes get paid, the creditors get paid, funeral home gets paid, the attorneys get paid, and then whatever's left over, they give to beneficiaries, of which these Florida statutes or the state statutes that you're in will decide. So every state's different, and they're called the intestate statutes, but every state has them. And if you don't have a will or a trust, then what happens is the state says, well, here's what's going to happen to your assets when you die, and you have nobody has any choice, even if you're intent with something other. Now, having a will is not enough, though, because a will pushes things into probate. A will does allow you to appoint your own guardian for any minor child, and it does allow you to appoint your own beneficiaries that get it after the probate process is done, but it does not allow you to trust.
So what's the difference between a will and a trust?
So the trust itself is an entity, and now there are different types of trusts. There's irrevocable, there's revocable, and there's different levels of revocable and irrevocable under those. But when we talk about revocable trusts, it's a disregarded entity, but it exists now. The reason why we call it a disregarded entity is you don't pay taxes any differently. You have your own social security number as its tax ID number. You're still the grantor, you're the trustee, you're the beneficiary. You can change it as many times as you want, add to it, subtract from it, get rid of it completely. You're not limited in any way. But as soon as you die, you have set, it's a contract between you, yourself, and your beneficiaries saying that, okay, what's going to happen? Who's going to take over when I die? So when it comes to, simple assets like a brokerage account or a bank account or a piece of real estate, it's simple. It goes into the trust. It's owned by the trust. You control it while you're alive. After you die, the beneficiaries will receive it in the way that you ask them or that you describe them to. So for instance, if for me, I have a 14-year-old and a 9-year-old, number one, they're not allowed to make any financial decisions until they turn 30. So the trustee manages it for them until that time. It also stipulates I want all education paid for and healthcare and maintenance, things like that. Even when they turn 30, it has protections in place, protecting them from divorce, creditors, litigation, bankruptcy, all the things they might face in the future. And then it stipulates that my grandchildren, not any daughter-in-law or son-in-law that I might have, are going to receive the eventual distribution afterwards. So those are the stipulations I put in place. A lot of people have certain restrictions or distributions that they want in their trust, but you can do that through your trust because the trust is a contract that you're creating with yourself. Whereas a will is not anything more than a piece of paper that's given to the court determining who's in charge of your estate and who eventually will get that benefit after you die. The problem with a will is that a will doesn't provide you any protection or privacy. A trust is completely private. A trust is creditor proof. A trust cannot be challenged. A will there's none of those things. So will has none of those protections. So a lot of people think they have protection because they have a will in place. And literally, I tell people, if you don't have a minor child, your will does nothing. There's no guardian appointed. So the only thing the will is doing is pointing to probate. That's it.
So in essence, what you're doing for your children is protecting them from them in spite of them, right?
100%.
Yeah. And you don't want any piercing of in-laws or their spouses that in this world, we never know how long those relationships last, and then you don't want things commingled. Once again, that 7-letter ugly word called probate. Can you give that quick definition, how to avoid that? I hate that word.
I know it is an awful word. Now, I will tell you a little asterisk next to what I'm about to say. I make a lot more money probating estates than I do protecting people from probate. I don't want any of my clients to go through probate, but there's a difference, and you were talking about before with asset protection. There's a difference between pre-need and at need. So if someone comes to me at need and they oh, my mom died, she didn't have any estate planning, it has to go through probate. But when someone comes in and we set up these trusts and we fund the trust, because the trust is like a safe, it's fireproof, burglar proof, waterproof. But if you leave the assets on the dresser, it's not going to protect anything. So you got to put the assets in the safe. And that's a very important part of the process with estate planning and with asset protection, to make sure that once the structure is set up, it's funded with the assets. Now, with the revocable trust, avoiding probate is so key, because probate is usually going to cost somewhere between 7 and 10% of the value of the estate. And on a short-term probate, we're probably looking at 6 to 9 months. Most of our probates go over a year. It's not in anyone's best interest to go through probate. Now, sometimes if you have a lot of creditors, this doesn't happen so often these days, but back in 2009, probate just to wipe mortgages of houses that were underwater. We don't find that much anymore, especially with the real estate boom that's happened over in my neck of the woods, over the last couple of years. But what we want to do is avoid probate at almost all costs. Make sure that we stay away from the court system, keep the assets private, keep the assets protected, keep the assets challenge proof, and put those things in place, protecting kids from themselves. Listen, my kids seem to be great young adults or young kids that are about to be adults, adolescents, whatever. Myself, when I was in my 20s, I wasn't a bad spender. I wasn't, crazy with my money. But if I would have inherited money at, let's say, 22 years old, I just graduated college, maybe I wouldn't have gone to law school. Maybe I would have said, hey, I inherited $100,000. I'm rich. Meanwhile, at 44, I inherit $100,000. I'm like, well, maybe I'll take the weekend and go on a vacation or something. Yeah, not changing my life. I'm still showing up on Monday.
Yeah, you didn't win that 1.3.
Life-changing money takes.
You didn't win that $1.3 million Powerball. Yeah.
Yeah, exactly.
We didn't talk about, we were talking about asset protection and all these things in Florida and some other states. there's to protecting your primary residence, we have homestead. Kind of one of the reasons that O.J. Simpson kind of moved to Florida, right? Let's talk a
Totally
little
true.
bit.
Yep.
Yeah, let's talk a little bit about homesteading and how to protect that asset.
So
Are there,
what's
are there
great is,
legal ways to eliminate those estate taxes?
oh, absolutely. And so when we talk about from a protection standpoint, both taxes and litigation. So from a litigation standpoint, there are certain assets in each state that are protected. And depending on what state you're in, I mean, for instance, in California, nothing's protected. Like the state wants everything to go away. But in Florida, we do have the homestead protection. Florida is actually one of the best states for asset protection. And as a side note, just because you live in a state and are domiciled in that state for estate planning purposes does not mean you can't do asset protection in another state. Hence why so many people have Delaware trusts, South Dakota trusts, LLCs throughout the country in Nevada and Alaska and things like that. So you can always do things to protect yourself in other states, even if you are domiciled in a different state. That's first and foremost. Now, in Florida, we have homestead that is protected. We have life insurance, annuities, retirement accounts that are qualified. They're all creditor protected automatically, which is great because we don't have to worry about those when it comes to someone taking them. We also, with accounts that have beneficiary designations on them, such as retirement accounts and life insurance, we don't have to worry about them going through probate. However, even if those assets are creditor protected and protected from probate, it does not necessarily mean that they're protected from the estate tax. So the IRS, when someone dies, they add up all the assets that they owned in their own name, and they figure out how much money do you owe us? Are you above the exemption or below the exemption? And like I mentioned briefly before, this year, we have the highest estate tax exemption we've ever had, which is $12.9 million. It's going to go up again next year, but at the end of 2025, when the Trump tax laws expire, it's going to drop down to $5 million. Now, in the United States, most people are not affected with a $5 million exemption. So it's fine. But if it goes below that, it's going to affect a lot more. And the funny thing is, people don't realize their net worth when it comes to estate planning, when it comes to the estate tax calculation. Somebody might say, well, what do I have? I have $1 million brokerage account. I have $1 million retirement account. And I've got, $200,000 in the bank, plus I've got my home. So what do I have? I don't have to worry about it. So, well, how much life insurance do you have? Well, I've got $4.5 million of life insurance. Okay. So that's added to the estate tax. If you own that life insurance policy, even though you can't use that money, the IRS is nice enough to say on the day you die, because that $4.5 million went into your beneficiaries, that you actually were worth that. Okay, well, you can't spend your house. You can't spend the value of your house. Well, it doesn't matter. The IRS is going to look at that and say, well, your house had a value. And if you had a business, the valuation of that business is very interesting, because if you were to argue the valuation of your business, just like I would argue the valuation of mine, once I die, what's my business worth? Well, the argument can be made while you're alive that your business isn't worth as much. But as soon as you die, the IRS is going to say, no, look how much money the business made over the last 3 years. Even though you don't exist anymore, even though you're not here to make that money anymore, the IRS says, no, we think the value of your business is way higher than that.
So let's
so
talk about,
you die and your kids are left with an estate tax liability.
Yeah. So let's talk about these irrevocable life insurance trusts, the ILIT, that lives outside of your estate. Naturally, I was guided because my fear was that the amount of monies that I had or my insurance might at that time exceed that limit, and then there will be a lot of money for taxation. So I took out a policy that if I died, if I had it and it was not in an irrevocable life insurance, could possibly put you over that threshold. But taking that policy that lives outside of your estate can actually go to pay some of the taxes if you go over that limit. You want to explain a little bit about that and how you handle those?
Absolutely. It's so important, especially when the exemption was only $1 million. And that's when I started my law firm. We were doing ILITs for everybody, because even if you had a $1 million life insurance policy, you became taxable immediately.
Correct.
The IRS says if you own the policy in your own name, it's added to your estate. But if you don't own the policy in your own name, then it cannot be part of your estate. You've gifted it away. So what we do is we create a different type of trust from the revocable trust I talked about before. This is called an irrevocable life insurance trust, where you name somebody else as the trustee and somebody else as the beneficiary. Most of the time we see a spouse or children as the beneficiaries. And if they're adult children, sometimes trustee. If it's a spouse, sometimes trustee, or even any U.S. citizen of 18 years old. The trustee's job, though, is to pay the premiums. The way that it works is you set up the trust and you set up an account for the trust. Then you, as the insured, donate the money, you gift the money. Let's say it's a $50,000 a year premium. You donate $50,000 to the irrevocable life insurance trust account, the bank account, and then you give what's called a withdrawal letter or a crummy letter to each of the beneficiaries. What you're saying is, I've given $50,000, I've gifted $50,000. You guys have 30 days to do whatever you want with that money. If after 30 days you haven't taken that money, the trustee is going to use it to pay the life insurance. The reason why that's so necessary is that 30-day period, you're actually hands off and you have said, I've relinquished control. That period of time allows for you to then, or your beneficiaries at that point, to show the IRS, look, he didn't have control of that money. He didn't have control of this insurance policy. If your kids are dumb enough to take the money and not pay the premiums, they shot themselves in the foot and they don't get the life insurance proceeds. So it's not a smart move. But usually what ends up happening is 30 days pass or you pay your life insurance. Then when you die, when the IRS says, whoa, didn't you have that $5 million life insurance policy? You say, no, I didn't. My life insurance trust had it.
Good. So people talk about offshore, all right? And you hear that word being thrown around a lot to avoid taxation and protection of assets. And let's talk about that. People, do you need offshore? You need to go offshore to protect your assets, like the Cayman Islands or in the Caribbean somewhere?
So I feel like with asset protection, this is one of the biggest misconceptions, is that the only way to protect yourself is by going offshore, because there are a lot of states, Florida, Delaware, Wyoming, Nevada, South Dakota, Alaska, that provide high levels of asset protection without raising a red flag to the IRS that you might be doing something, from that shady from an income tax standpoint. And the other side of that coin, the reason why, and don't get me wrong, we do set up offshore trusts and LLCs, maybe, 2-3 times a year for clients when necessary. But the other part of that is people think once they go offshore, oh, I'm outside of the US jurisdiction, so now nobody can take my assets. But that's not true. So if you set up an LLC where you are in, let's say, Cayman Islands or Nevis or Cook Islands, wherever it might be, you set it up and you are the trustee of that trust, or you are the manager of that LLC, and you are sitting here in your home state in the United States of America, and you get sued and you have a judgment against you, and you say, well, my assets are offshore. You can't force me to bring those assets back. They're not under your jurisdiction. The judge will say, well, you're under my jurisdiction, and I'm going to hold you in contempt and put you in jail until you bring those assets back and pay the creditor or the divorcee or whoever it might be that's suing you. So in the situation where you are going offshore, it is crucial that somebody else, not you, is the trustee or manager of that trust or that LLC. And then what you're doing is you're actually hiring a stranger to manage your money. Now, it's done, and there are reputable firms that do it, but the only time we go offshore usually is if it's like a cyanide capsule in a James Bond film. It's the last ditch effort to move stuff around, and we're usually not even doing it for full protection. We're usually doing it to get to a settlement, because if you already have a judgment against you, you're going to be writing a check. We just want to make that check as low as we can. So by moving things offshore, sometimes it's worth it. We go back to the other side and say, look, you can try to petition the judge to have me bring that money back here and domesticate it again, or listen, I'll give you 25 cents on the dollar. We settle this thing right now. So that it's used as a strategy, but we still, sometimes offshore is used, but it's so crucial that if you go offshore, that you are not in charge of the offshore money.
So the bottom line is you don't have to go offshore, just give them to shore.
Exactly. Very good. I love it.
So if my assets are protected, all these things that you said, do I still need insurance?
So we talked a little about malpractice insurance and why sometimes there's a strategy of not carrying it. But when it comes to all other liability insurance, I still say carry it. The fact is that just because you're creditor proof does not mean you can't be sued. So you could have all your assets tied up where once they get a judgment against you, if they get a judgment against you, they're not going to be able to attach that judgment to any of your assets. But that doesn't mean you don't have to pay your own legal fees. Now, insurance, people don't realize the insurance actually pays the legal fees for you too. And you could get into a lawsuit. These lawsuits take forever. Even if you're completely innocent and you win the case, you might have spent $200,000 in legal fees. So I always say, keep liability insurance. You don't have to go crazy with it. I have a lot of clients that come to me, they get umbrella policies that's as big as their assets instead of as big as their liability. So I have a client that came to me at a $10 million umbrella policy. I said, are you flying kindergartners around in your private jet? Like, what are you doing? That's this much liability. And it turned out he really only needed $1 to $2 million worth of liability insurance. You don't need to have enough liability to cover your assets. You only need to have enough to cover whatever potential liability you might have. But I still think it's a good idea to have insurance.
Do you think it's true that now you're basically on the defense side than you are on plaintiff side, but do you think it's true that the more insurance that you have, the bigger the Pandora's box you have to open from the other side?
Definitely. There's a magic number on how much insurance you should have, because it is totally true that if you have a $5 million, for instance, umbrella, and let's say you were in a tiny fender bender, you're getting sued. Like they're going to try and they're going to sue for a crazy amount. It's going to be where somebody sues for $5 million and the insurance company goes, get out of here. But it's like, well, all right, give me something. I know you have 5 million. Give me something. Right. I found that, when it's, for instance, even myself, one time I got called by an attorney who they were trying to shake out some estate plan where the client died and he had given to certain beneficiaries, but not given to others. And one of the beneficiaries hired a lawyer to see if they could collect some money. And they couldn't because everything was done in trust and everything was protected. But they called me and they said, hey, well, we're going to put a claim in against you because you did an estate plan and it didn't include the client's brother. And I said, well, they said, oh, they wanted to know my carrier, my malpractice carrier. And I said, well, I don't carry malpractice insurance and I'm an asset protection attorney. So good luck to you. And that was the end of that. So there is some benefit. There is some benefit to not having the insurance when it comes to things like that. But it also is a benefit because if they would have sued me, then I would have had to come out of pocket at defending it, even though it was a frivolous lawsuit. And you could always challenge if it's truly frivolous, you can challenge and try to get your attorney's fees back, but it's very difficult. So it is good to have a certain amount. If you have too much of it, though, to your point, I do think you are opening up a target on your own back.
So one of the things that most people, I had a question that came in, and also, what if you've already been sued or you're about to be sued? Can you protect your assets at that time, or is it too late already?
So it's never too late. There was a judge actually, and he was a conservative judge, and I was shocked by his response to this. He was asked one time, can I still do something? There's a judgment against me already. And the judge said, well, if you don't do anything, we know what's going to happen. If you do something, at least maybe you can save some assets. And that's usually what I express to my clients is it's never too late. It's never too late. Obviously, the earlier you start, the more options you have. If you come to me and you've never been sued and you don't have any issues, there's no potential creditors, you're not expecting to get divorced, you're not doing, we can do everything. We have a litany of choices and we can legitimately protect you. We can use limited liability partnerships. We can go to different states. We can even go offshore if we need to. There's tons of stuff we can do. Once the incident occurs, no matter what that incident is, now the clock starts, because now, if you're doing anything between the incident and the judgment, you have to legitimize it. So you have to be able to show that your purpose of doing this was not to defraud a creditor, but for some other purpose. Maybe it's a business purpose, maybe it's an estate planning purpose, whatever it might be, but you have to legitimize it. As you go down that road and get further and further along and get closer and closer to that judgment, or even beyond that judgment, now we're playing the money game, the negotiation game. And now you're not worried about the law. You're not worried about the judge. You're not worried about the court. You're not worried about the precedent. What you're worried about is which attorney is suing you. Because, and this is what first thing I do when someone comes to me and they already have a judgment, I say, I need to know what law firm is on the other side. If I see that it's a mill, personal injury law firm, and it's one of these, Morgan and Morgan, nothing against these firms, but they know what they are, so they're looking to move fast, So when I see it's them, I go, you're fine. They're going to take your insurance. They're going to go away. They're not looking to prolong this into a litigation. If I see on the other side, where it's a first-year attorney that he lists himself as a real estate attorney, and he's probably doing a favor for a friend, I say, they're not even going to get the insurance. They don't know what they're doing. They're shaking a tree, hoping something falls. They'll take $10,000 and be on their way. When it's a lawyer at a firm that instead of on a contingency, they're getting paid hourly to sue. And this usually only happens in business disputes. It never happens in like injuries, but in a business dispute, they're getting paid to sue because the other side, they'll happily spend $1 million just to get 100,000 from you. That's the danger. And then what you have to do is you have to play the game. You have to say, okay, I'm going to make this so difficult for them as far as, when you have one pawn left on the chessboard and you just keep moving it around, right? You say, I'm just going to keep moving and make you chase me. And eventually, hopefully you get tired and you just call it a draw. So in this case, they are looking to acquire assets as easily and quickly as they can. If you tie up your assets in a number of different baskets, so we use a limited partnership, we use irrevocable trusts, we use, LLCs, and we start moving things around, it's harder for them to find them and it's harder for them to acquire them. And so then you go back and you say, okay, well, what kind of deal can we make? But any client that comes to me and says, well, I don't want to pay anything, I say, you're unrealistic. But I did have my biggest win I ever had was I had a client that had a $20 million judgment against him when he came to me. So he already had the judgment against him. He was being sued by a big law firm. I won't say their name, but it's one of the firms in Fort Lauderdale. It's a big firm. They got 100 attorneys. And we tied up all of his assets. And we ended up 6 months later settling that lawsuit, that judgment, for $650,000 from $20 million. So he ended up saving $19.5 million. And now I eat for free at all of his restaurants.
That's cute. So let's say now that that you're being sued and that you want to dump a lot of your assets elsewhere, and you want to have what they call the fraudulent conveyance. You want to talk a little bit about fraudulent conveyance statutes?
Absolutely. That's the biggest question I get when someone comes to me with a judgment against them or an incident has already happened. They're worried about the fraudulent conveyance statute. So they actually changed the name of the fraudulent conveyance statute recently to the Reversible Transfer Act. But I still like to even say the fraudulent conveyance statute because that is what people are thinking of, like it's fraud. Well, it's not. And this is very state specific, I want to also say, because in California, it is completely different. In fact, California, if you fraudulently move assets, if you move assets with the intent to deprive your creditor or judgment holder of that asset, it could be criminal. So you want to say if you're in California, seek California advice. But in Florida and in most states, there is no penalty for moving assets after the judgment. The only penalty if you get caught or if the judge finds that you are doing it with only that intent to deprive, then they reverse that. That's why they call it a Reversible Transfer Act. They say, hey, nice try. We're going to take that money that you spent on that new homestead. We're going to put it back into your name. And now we're going to give your creditor another shot at getting it. Doesn't mean the creditor gets it. Just means now they get another shot because now it's back in your name. So the most important part of asset protection is actually estate planning. I love it when someone comes to me and they have a very high net worth, or they have a couple of businesses, or they have all these different things going on, and they've been sued, and they say, I don't know what to do. Because now what I can say is, well, do you know what you haven't done yet? Is you haven't done your estate planning. And especially if they haven't. If they have done it already, we don't get to use this argument. But if they haven't done it already, then what we say is, well, here's what we have to do. We have to worry about the estate tax. We have to worry about probate. We have to worry about what's going to happen with your kids with all these assets you're leaving behind. And after we set up this structure that is completely protected from an estate tax standpoint, it just so happens a side benefit of that is completely protected from an asset protection standpoint. And when they go then to court and have to, and it never gets to this far where they actually have to say it to court, but if they were to have to go to court and say, well, what is your reason for having moved your assets? They can legitimately say estate planning, legitimately say it, and they can show the process in which we accomplish that. Now, the fraudulent conveyance statute, there are 3 tiers where the opposition has to get past all 3 to prove something was a fraudulent conveyance or was a reversible transfer. Number 1, did the debt already occur? So was there a judgment or an incident that already was in existence at the time you made the transfer? Number 2 is, did the transfer of that asset make you insolvent for the purpose of paying that debt? Right. So if you're moving stuff around, if you owe 50 grand to somebody and you still have 50 grand in your account, they can't say moving the other stuff was fraudulent. You still could pay the debt. And then the third, and this is where really we get to be creative, is was there another reason for moving that asset other than avoiding that creditor? And that's where the estate planning comes into play. And sometimes it's not even estate planning. Sometimes it's actually like business operations. People think that once they get sued, they have to stop living their lives the way they were living them. No, if you're still running your business, if you're still buying real estate, if you wanted to move, like there's no rule that says you can't do those things. It's just where people get in trouble is they're like, I'm just going to put everything in my brother's name. It's like, no, that doesn't work.
All right. Now, as we're getting ready to conclude this, you have people as young as you, and then you have people as old as me. I like to kid that the picture that we took of you and I, it looks like a before and after. You look like a Rob Lowe and Ben Affleck, and I'm looking like Sean Connery, at this point in my life. All right. How soon is too soon to start? Because we have client base that has just come out of their residencies and are just going into their business venture of opening up their practice for the first time. It's the big step of their life. They either come out of institution, academia, working for somebody, or out of a residency, and we help multitudes of doctors and surgeons open their business. And one of the first things that I speak to them about is a business plan. Don't go into a business without a business plan. And the second thing I speak to them about is, are you married? All right, seriously. And do you have children? Well, Jay, why do you ask? Well, let me share a story. And I go into my own personal story, and it's you're never too young to run into a tragedy. So when is it not a good time, or what's the best time? How soon do you start your asset protection plan?
Well, so it's funny you say that. So I often, people think that estate planning is for the old. That's what they think. Well, I'm not going to die tomorrow. I mean, first of all, I always tell everyone, if you know when you're going to die, just come to me a month earlier and then we'll be fine. It's fine. Then it's no problem. Most people don't know when they're going to die. And like I mentioned before, the death rate's 100%. So nobody gets out alive. And the important part about estate planning is it's funny. It's not about the money and it's not about the age. It's about the beneficiaries. Because I had a client years ago, I still remember, he actually had set the record for the largest real estate deal in Queens, New York. So this guy had a ton of money, sold like 4 apartment buildings, and he came to me for estate planning. This is a gentleman that is on his first marriage still, so there's no issue with that, but never had any children. And everything's going to charity. Just decided he wanted everything to go. So there really was not much planning to do. We wanted a plan for him as far as get his power of attorney and his healthcare surrogate and make sure his wife's protected when he passes. But estate tax wasn't going to be an issue but when both of them died, it was going to go to charity. And during his life, it wasn't an issue as far as, asset protection because he had already cashed out. So it's simple LLC. It's not a lot of moving parts. He was already retired. There weren't a lot of worries. However, on the other side of that, then I had a client that their net worth is probably about $1 million, but they're on a second marriage, each having kids from previous. And one of the kids has special needs. And then they have a son-in-law that they don't like. So for them, estate planning is crucial. I think that if I die, I am a single dad, I'm a divorced dad with 2 minor children. If I were to die without estate planning, and that includes the planning of life insurance and retirement plans and things like that, if I were to die without planning, my kids would be crippled for a very long time. They would be financially and emotionally crippled, and they might have to go through guardianship. It might have to be where the assets are in probate if I didn't plan. Whereas, when my grandmother died recently, now I set up her estate plan so she didn't have to worry about it anyway. But when my grandmother died, she died at 96 years old and literally had 3 assets. She had a retirement plan, a bank account, and a brokerage account. All 3 accounts had my parent, my father, my aunt, and my uncle, who are all in their 70s or 60s and 70s. My aunt would kill me if I said 70s, but they were all grown, and it's not a ton of money. And even if my grandmother did not have a trust, it would have been fine. It would have been fine. So I think that the key is, who are your beneficiaries? Who are your loved ones? Who are you trying to protect? Because if you have that, then you need to do it now. If you have a baby, if you have a grown child, whatever it might be, you have to protect the loved ones, not the money as much.
Very important to know that just because you do it, I always say that the part of a business plan is to create it, review it again, and review it again, and modify and/or change. And let me give the perfect example. 11 years ago, after my late wife passed away, then I created my estate plan, from my wills, my trust, my estate, and Michael took care of healthcare surrogate and power of attorney. We did that. And then, much to my blessing, I got married again. And I then came back to Michael and I said, look, my circumstances have now changed. All right. And we need to now redo my asset protection. And then my wife now was also a widow. And she then had to create her asset protection plan and her living trust so that it had to be done again. And I don't think that I'm an anomaly in this world. I mean, with first marriages and second marriages and now third marriages, you have divorces, and then you have, your spouses pass away. And sometimes people forget to change these. And if you're divorced, you certainly may not want your former spouse to be the beneficiary. Your children are a different story, but you may need to remove those people that you no longer want and modify. So how often should you do this, Michael, if once you start this plan?
It's a very, very good point. In fact, I always usually say, depending on the age of the person that's setting it up, it's going to be somewhere between 3 and 7 years, every 3 and 7 years. So for instance, if you're on your first marriage and just had your first baby, you might not even be changing it until you have your second baby. Or if you're done having babies, but they're young still, it might be 10 years before anything happens because the rest of your family's young too. But when you're older, then it changes a lot, because then there's birth, death, marriage, divorce, and it doesn't only have to be yourself and your immediate family. You could have your brother listed as the trustee for your kids, but then he gets divorced, moves to Vegas, and starts partying every weekend. And you're like, well, maybe he shouldn't be the trustee anymore, So those things happen too. And then I've had so many times where someone will come to me with a trust that's 20 years old. Like, I've got actually a friend of mine sent me his yesterday. He sent me his will. He goes, Mike, I'm embarrassed. I haven't updated this will. This gentleman, I know, he's an older guy, and I looked at it and it said my wife is pregnant with our 4th child, and it was from 20 years ago. And I'm like, okay, you need to update it, and it doesn't even have the 4th kid in there. And some of the people on there are no longer with us. So yeah, it's important to make sure that anytime there's a change in the family or in the assets, sometimes I have serial entrepreneurs, which I imagine a lot of people on this call might be, because they're business owners. And once you own one, you like to be involved with multiple. So if you then add more businesses, but you forget to change your trust or add them to your trust, well, now you set up the first structure, but you didn't add to it later. And then we're going to have to probate those other assets, which we're trying to avoid. So I really think that, at least every 5 to 7 years, you want to sit down with your estate planning and asset protection attorney and review what you have and how it's changed since the last time you got together.
Yeah, exactly. Because after I got remarried, now, I have the introduction of new grandchildren. And now I'm about to become a great grandfather next month. And in my estate planning, I want to make sure that we provide for education for these children, and a new education and a trust fund for the grandchild that is about to come. And as I went and did my revisions of my wills and trusts and estates, I'm trying to explain all of this to Michael, and my wife is explaining all of this to Michael, and we have to change documents and then rechange documents. I mean, it's a good feeling walking out that it's done, but it's an arduous process, and you have to make sure that you keep everybody in mind with that. As we conclude, I'd like to be able to give contact information. So if you would like to be able to get in touch with us, Michael, please share with the audience how they can get in touch with you for your consult or guidance in their wills, trusts, and estate planning.
Absolutely. And as you can see, my email address is right there on the screen, mwild@wfplaw.com. And anyone who wants to call the office can also call at 954-944-2855. As you mentioned, I'm 44, so I'm fairly young for an estate planning attorney, but I'm the oldest person at my firm. So even if I have deceased, I have 3 other attorneys that are backing me up here, because I'm not free of the risks either. But we've got a great team here, and everyone here handles estate planning, asset protection, and probate administration only. So we are not dabblers; we are specialists in this area.
Perfect. And feel free. This will be episode number 95 on our podcast and webinar series. You can contact me at jshorr@shorrsolutions.com. Our website is www.shorrsolutions, plural, because we have more than one solution.com. And our handles on social media are at Shorr Solutions. So ladies and gentlemen, on behalf of Mike Wild, my colleague and my personal wills, trust, estate attorney, please allow me to thank you for spending an hour of your day with us. And I hope that we were able to give you some good information. Please feel free to visit our websites or call if we can assist you.